Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Well, this one is not a whodunit. It's a whydunit, and the facts are just bizarre. Annette Harvey has pled not guilty by reason of insanity to first-degree murder charges in the death of Robin Leonard. Now, Robin Leonard, one of her lifetime best friends, was a psychology professor at Eastern Tennessee State University. At the time of the stabbing, Leonard had physical custody of Harvey's children. Now, the incident, the stabbing, occurred at Leonard's house. When fire department people arrived and the cops arrived, they found that Leonard was bleeding severely from multiple stab wounds to the chest. She told them that Harvey had stabbed her and that Harvey had allegedly fled the scene. Now, that detail, the fact that she fled the scene, is going to be important later on. Harvey was arrested later that same day, and Leonard was taken to Johnson City Medical Center and lingered there for 11 days before she ultimately passed away from those 8 stab wounds. Prior to the stabbing, Leonard had reportedly moved Harvey's 2 young children to another home because Harvey had taken them from Leonard's home 2 days earlier. The kids were not hurt. The defendant is asserting the insanity defense. Now, we'll have to see whether or not that fits the facts of the case. Let's start by watching a little bit of the state's opening, where the prosecutor initially tries to sort of humanize the victim in this case.
I want to start off by talking about the person who will not testify in this trial this week, Robin Leonard. She is a subject of this case too. She's the one who died. That's a picture of her when she was alive. And you're going to hear in this proof testimony from her son, Alexander Leonard. He's grown now. And you're going to be able to tell how proud he was of that woman. He's going to tell you he's the only child. She had him when she was in her 20s. She had dropped out of college, was alone raising him. She waited tables, she bartended, tried to make ends meet. Went back. She was going downhill quick, fast. There's a 911 call you're going to hear very soon in the proof.
This is after the stabbing.
Where it's dialed in, no one's really talking, and then someone says something, and it's, "Please, Annette, don't hurt me, please." Something like that. Johnson City Fire Department is the first responder to get there. I think they got a little mixed up on where the distance was because there's a fire department. He's not coming from far, but they have to get the location because they're not really getting good direction. Lieutenant Rick Casey is the first one to make contact with Miss Leonard, and Miss Leonard tells him also, Annette Harvey did this. Of course, nobody knows who Annette Harvey is that she's talking about at that point. They don't even know her name because she can't talk well enough to do it. And Lieutenant Casey's going to tell you that he accompanied her on the ambulance down to the medical center, and she's just going to where she's non-responsive.
So the prosecutor didn't offer a whole lot of, bloody gloves, so to speak, to establish what happened here. And I thought it was a reasonably effective opening. You'll notice that he has a very conversational tone with this jury, that he's very comfortable in front of this jury, and that he's pretty sure of himself in this case. And I suspect this is a seasoned prosecutor who is doing this murder trial. And I really wish that the whole trial was going to be broadcast. The first day was not broadcast, and there do not appear to be any videos of it. So, unfortunately, I can't tell you what the witnesses have said here, but this this opening I thought was a really good way to start because he talked first about the victim. This is who it is. This is what happened. And then he talked about what happened, and then he talked about who done it. Now, he knows that there's an insanity defense, but he also knows that he doesn't have to prove anything, as I'll explain here in a little bit about the sanity. So rather than go through the rest of this opening, I want to take a look at how the defense previewed their case. And I want to point out that there are some allegations here that are of a nature that if I mentioned them, I might get my channel demonetized, and I wouldn't want that. So you're more than welcome to go on YouTube and find this entire opening statement and listen to all the salacious details if you want to, but the heart of the insanity defense is set up by just a few segments here in this defense opening statement.
This is a complicated story and one of tragedy. It's about a powerful and enduring friendship that spans the decades.
Interesting that this powerful and enduring friendship ended when one of the enduring friends stabbed the other one. But let him go on.
The beginning is Bristol, Tennessee. Annette and Robin are little girls who connect at first sight. Junior high, high school, boys, pictures, yearbooks, and secrets shared.
Okay, so we can tell right off the bat that just like the prosecutor, he is very comfortable with this jury. And he's also a good storyteller. He hits all of the points that most of us remember from high school, yearbooks, our dating life, that sort of thing. And I think he does a really good job of weaving in some details that also serve to humanize the defendant. So let's go on.
Between them grow pillars of trust, faith, and reliance on each other. They protect each other, and they are bound in their Christian faith with one. As time rolls on, there are husbands and children, birthdays and cards, evening calls after the children are down. In a short phrase, they loved one another, and like any deep friendship that lasts the test of time, it is not for others to completely understand.
Now, that also is an interesting turn of phrase. He's basically telling the jury, look, you can't be outside this relationship and reach some kind of conclusion about what the relationship is. So I think he's trying to set up the fact that, Ms. Harvey went a little bit overboard here.
On November 29th of 2020, Annette, her husband Michael Slattery, and their two young girls traveled from their home in New Jersey to East Tennessee to celebrate Annette's birthday and visit with friends and family. This will be the first time she discloses her secret to Robin. You know, it is one thing to consider the desperation that Annette must have felt.
Now, at this point, I would point out that the secret, again, has to do with children and things that are not really appropriate for me to discuss on YouTube.
But quite another to think about how fearful and protective Robin was feeling. Without knowing it, they are now fueling each other's paranoia.
And there is the heart of that defense case, which starts with paranoia and goes obviously to insanity. Now, Tennessee is probably the worst state in the Union for the insanity defense. The legislature amended its statutes a couple of years ago and changed a bunch of stuff, likely in response to the frequent use of the defense and the fact that there are always experts willing to come into court and say someone is cuckoo for Cocoa Puffs. But in Tennessee, the insanity defense is governed by statute. It is an affirmative defense to prosecution that at the time of the commission of the acts constituting the offense, the defendant, as a result of severe mental disease or defect, was unable to appreciate the nature or wrongfulness of the defendant's acts. Mental disease or defect does not otherwise constitute a defense. The defendant has the burden of proving the defense of insanity by clear and convincing evidence. As used in this section, mental disease or defect does not include any abnormality manifested only by repeated criminal or otherwise antisocial conduct. And then in section C, no expert witness may testify as to whether the defendant was or was not insane as set forth in subsection A. Such ultimate issue is a matter for the trier of fact alone. So, the elements of the insanity defense found in that current version of the statute, which is section 39-11501, you just saw that, are as follows. At the time of the commission of the acts constituting the offense, the defendant, as a result of severe mental disease or defect, was unable to appreciate the nature or wrongfulness of their actions. Or more simply, the elements of the insanity defense are that the defendant, at the time of the offense, 1. Suffered from a severe mental disease or defect, and as a result, 2. Was unable to appreciate either A. the nature, or B. the wrongfulness of their acts. The first element is that at the time of the offense, the defendant suffered from a severe mental disease or defect. Now, the statute doesn't really tell us what a severe mental disease or defect is, so that's actually a medical diagnosis. Some of the examples from the cases include things like schizophrenia, delusional disorder, bipolar disorder with psychotic episodes, schizoaffective disorder, brief psychotic disorder, moderate mental retardation, and major depression. However, when you get right down to it, in most of these cases, the element of severe mental disease or defect isn't even in dispute. It's the second element that is the tough one. The defendant must not be able to appreciate either the nature or the wrongfulness of their acts. Now, whether the defendant understood the nature of his actions or the wrongfulness of his actions are two separate prongs, and a defendant only needs to prove one of them. The inability of the defendant to appreciate the nature of their acts is, for example, somebody operating under a delusion. You know, they're being attacked by an alligator and they're stabbing the alligator, except the alligator is a person and they're not being bitten by anything. As for the term wrongfulness, it's not defined in the statute. Case law basically says that it's the inability to understand what they were doing was wrong. Tennessee Court of Appeals has held that the instruction that gives that definition is the complete and correct charge of the current law concerning an insanity defense. Because it is an affirmative defense, the burden is on the defendant to prove that defense, just as it would be in a civil case. In many states, this burden is limited to the preponderance of the evidence standard. In other words, 51%, just more likely than not likely, but not in Tennessee. Under prior law, if the evidence introduced raised a reasonable doubt about the defendant's sanity, the burden of proof then fell to the state to establish sanity beyond a reasonable doubt. That sort of tilted the playing field in favor of the defendant, and they didn't like that. So they created a significant hurdle by changing that. The current version of the statute says insanity is an affirmative defense and that the defendant has the burden of proving a defense by clear and convincing evidence. Clear and convincing evidence is a step above the preponderance. While the state's required to prove all the essential elements of a crime beyond a reasonable doubt, sanity is not an element of a crime, so they don't have to prove that. As such, the Tennessee Supreme Court has rejected the notion that the state has to rebut the defense with evidence. In determining whether a defendant is insane, the trier of fact is entitled to consider all of the evidence offered, including the facts surrounding the crime, the testimony of lay witnesses, and expert testimony. The jury, or the judge sitting as fact finder if it's a judge trial, isn't bound to accept the testimony of the experts when the evidence is contested. In other words, the trier of fact can decide to believe some witnesses or any witnesses or no witnesses. It can believe some and disbelieve others. It can believe part of the testimony but not all of the testimony. So there is a lot of leeway that is given to the trier of fact, the finder of fact in these cases, whether it's the judge or the jury. They get a lot of leeway in weighing the expert testimony as well as the lay testimony. So all of these people can testify to their observations, and also the state will vigorously cross-examine any of the defense experts, as well as most likely putting up some of their own. Now, the current version of the statute makes the defendant's burden of proving the insanity defense really tough. Since the amendment, there has been only one case where the insanity defense has prevailed, but there have been numerous cases where it has failed. The Tennessee Supreme Court affirmed a jury's rejection of the insanity defense in State v. Flake, which is almost a play on words. Even though 4 expert witnesses testified the defendant was unable to appreciate the wrongfulness of his conduct, and a 5th expert witness testified that the defendant felt morally justified in his conduct. Instead, the court noted that the facts surrounding the offense suggested the defendant realized his conduct was wrongful. Remember how I said that Harvey's flight away from the scene would be important later? Well, the Flake court relied in part on the fact that the defendant fled after the shooting and that he appeared to realize he had committed a crime. At the time of his arrest, he exhibited no bizarre behavior. So, in that case, the Tennessee Supreme Court had no problem saying, no, that the jury got it right here. But let's take a look at that case where the insanity defense prevailed. That's State versus Kennedy. And the jury in that case convicted the defendant of vehicular homicide and 3 other offenses, but the trial court granted the defendant's motion for judgment of acquittal on the grounds that she'd established insanity by clear and convincing evidence. The state appealed, and the Tennessee Court of Criminal Appeals affirmed the trial court's decision, saying the trial court relied on the fact that 3 experts testified that the defendant suffered from bipolar disorder with psychotic episodes, and that she could not appreciate the nature or wrongfulness of her conduct, and that there was nothing in the defendant's actions leading up to the offense to counter that opinion, and the defendant's statements after the offense clearly evidenced a continuing delusion. So, in most states, and indeed in Tennessee, the rules permit an expert to opine on an issue of ultimate fact. In other words, in Missouri, the expert can come in and say, oh yeah, that guy was just completely nuts. He's like a Snickers bar packed with nuts. In Tennessee, they can't do that. They can't offer an opinion on sanity. The expert witness can testify that they suffer from a severe mental disease or defect, and the expert can also say, well, they couldn't appreciate the nature and wrongfulness of the conduct at the time of the offense, but the expert cannot connect the dots for the jury. So the expert can't say, well, he had a severe mental disease, bipolar disorder, and that defect operated to keep him from being able to appreciate the nature or wrongfulness of his conduct, because that isn't essentially the expert testifying that he's insane. As you can see, this is going to be an uphill battle for the defense in this case, and it'll be interesting to see where it goes. Hopefully they will put up some of the expert testimony, the videos of that, and we can take a look at it. Otherwise, this may be a one-off video. I don't know. I always hope that the cases will be there like they were in the Crumbly case, where you can see for yourself everything that the jury relied upon. So that's what I have for you today. I thought it was an interesting topic. If you have any questions or comments, put them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. Thank you so much for watching. If you have an opportunity today, do something nice for someone. And then catch me down here at the beach again tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.